And this is Garlington speaking with Mr. Copeland.
Hello. Yeah, nigga, I could hardly hear you. What you?
It's fine. I mean, I was just going to ask, is the summary of it, that's essentially what it says?
Yes, Your Honor.
And the purpose of it would be consciousness of guilt, what?
So it's a number of things. One, Mr. Copeland is telling Garlington, you better be careful on social media because I just talked to, I believe he's talking about Mr. Sledge, said there's a 43-man RICO indictment. This jail call, or not jail call, this wiretap call is April 23rd of 2022. So the indictment was May of 2022. And there's another call we haven't gotten to yet on Antonio Summons, where he's basically saying this why Copeland is in jail, in prison, gang task force, there's some issues in jail, and they're coming at him. And so someone says, I also talked to Copeland, and he says, basically this YSL stuff is hot, and you better fall back. It's actually another male calling someone, referencing the conversation. And so, to me, this is a co-conspirator statement in furtherance of the conspiracy against Copeland and Garlington by warning him that, hey, they don't know if it's true or not.
Right.
The timing and what they're discussing is pretty close to when this indictment came out. It wasn't 43, but it was 28. But nonetheless, it's him warning him, hey, be careful. That's what Sledge just told me.
Okay. Any objection to this evidentially?
Your Honor, relevance, again, we're talking about two individuals that are not sitting here at trial, and I don't believe that they purport to be speaking on behalf of anyone here at trial, and any motivation they would have would be self-preservation. So I believe it's hearsay, but leave it with the court.
Okay, well, it is hearsay, but I think this comes in under the co-conspirator exception, admitted.
We only have one more from Mr. Garlington's wiretap, which is reference number 4959, PDF page 5000. And we believe this, Mr. Garlington is speaking with the same Mr. Wright we had discussed earlier. And we're going to start at 28 seconds and play to 1 minute and 41 seconds.
Okay, well, is it accurately summarized? Is that the gist of what I need to know?
Yes, Your Honor. This is the call I had referenced earlier when we were discussing drug sales.
Okay. Is there an objection?
Yes. This is exactly what I was talking about. Garlington is selling drugs on his own to fill his own pockets and has nothing to do with my client. Garlington claims that my client, who at the time of this call is in jail, mind you, so it's nothing that's happening as they're speaking.
Well, I don't know about that. I mean, it seems to me that we've got plenty of evidence here that lots of people in jail have access to phones and social media and what have you.
Point well taken.
May not.
Point well taken. All right, so, but he is just basically almost jealously or saying, boy, I wish I could sell drugs on the internet as well as Shannon used to, or as far as I've seen Shannon do.
Some unknown time period.
Yeah, right.
Have.
And so, you know, I'm not acknowledging that Shannon was selling drugs in 2022 on the internet, but even if he was, that has nothing to do with what Garlington has going. This is actually proof that Garlington and Shannon aren't some unified drug dealing organization. And so Garlington's just saying, yeah, I don't know how Shannon does it, and I wish I could do it. And this is what I would do. I mean, it's hearsay. It's not in furtherance of any conspiracy. It's bad character evidence, and it's irrelevant.
Your Honor, I think this kind of falls into also the category of a declaration against interest in terms of their discussing amongst each other their drug sales, how to sell more Percocets, and he's like, you should try putting it on Instagram. And so in terms of getting through a hearsay objection, the state feels the most applicable exception to what they're talking about, which is selling Percocet pills, is there's some indicia of reliability because they're making statements that, you know, if it was that Mr. Wright and Mr. Garlington is against their interest to be discussing. And so in terms of if they're being, so that's the state's primary argument is, you know, discussing how to better sell narcotics and talking about their own narcotics and essentially dealing and how to boost sales, basically.
The thing
Well,
about
I suspect that Mr. Schart's problem with it is not the two of them discussing it. It's the mention of Mr. Stillwell and his alleged methods for selling illicit drugs.
correct.
Yes, Your Honor.
Okay, so
The state, so his objection is a bad character or?
well, I mean, it's
Well, the
certainly-
declaration, we litigated this on a different matter, but the state tried to argue declaration against penal interest. The thing about declaration against penal interest is you're allowed to declare things against your own penal interest. What you're not allowed to do is declare things against other people's penal interest.
well, that
and-
doesn't get it in.
Right. And so that's my issue.
So it's essentially, yeah, just the kind of gratuitous mention of what Mr. Stillwell might be doing. Like, where's the foundation for
So, Your Honor.
why, or not the foundation, but the exception that lets that part in
In terms of it being bad character?
and hearsay?
So the state feels that Garlington making that statement, I guess, and I could be wrong, my mind, him discussing how Mr. Schart's client is successfully selling Percocets on Instagram and how Mr. Wright needs to try that strategy is wrapped up in my mind in the same, he's making that statement about their own drug dealing. And so I view it, and the court may view it differently, but I view it in that bucket of a statement against interest. It's part and parcel of that.
Oh, dude, man, got out from the right there. They had run to serve somebody. They probably be back already.
He probably, I thought he said he was on Boulevard.
Yeah.
Yeah.
Hey, you don't want to
Yep.
put them. You don't want to put them perks on you paid, bro.
Oh, what for?
Perks I got.
You want to post? I post.
Nah, I know. You know,
I don't never. My shit never sell for Instagram, bro.
For real.
Bro, I always post personal shit. My shit never sell for Instagram. That's why I don't read them doing that type of shit.
Oh yeah. Okay.
Yeah, my shit never sell for Instagram. I was like, what the
Nah, I
fuck?
seen that. That's saying if you doing that shit, bro, that's what he was getting hit.
Yeah, nah, he was doing that shit. Some folks will be, they'll be hit when the motherfuckers gone and shit. Like,
Yeah.
man, the motherfuckers gone.
Yeah. That's that one.
Billionaire hoes and get the, like, riding by where you be at and shit, you for the motherfucker.
Yeah.
I supposed to know. Somebody might bite. Goddamn.
Damn, man, I don't pick it.
Your Honor, upon further consideration, the state cannot play this.
Okay. There we go.
I'm thinking through what Mr. Schardt said and my thoughts, and so
All right. Okay, so that's the end of the Garlington wiretap, I believe. And who's the second wiretap?
it's, Your Honor, it's Antonio Sumlin. He's in a little different category because he's someone the state intends on calling at trial.
Okay.
So mean,
Should we need to address this right now, or?
I don't believe we do, Your Honor, because a lot of his call, I mean, there is some that I believe are co-conspirator statements, but he's also a testifying witness, so some of these are going to be more an impeachment.
Okay. All right.
Up to the court, Your Honor.
Well, I mean, obviously, I, some of these say, and a lot of these say entire call, and I don't know exactly the length or substance of what an entire call is, but it seems like if it's to impeach, then depends what he's saying, and maybe I do need to know beforehand what's on there to know whether it's actually impeachment or not.
Yes, Your Honor, and I guess I should be, so the state believes that these 9 that we included, if Mr. Sumlin was not testifying, the state's position is they are co-conspirator statements. I just wanted to highlight that, unlike Mr. Garlington, we are expecting him to be called.
Okay.
So we have 9 highlighted, so we can turn to Mr. Sumlin's if the court wants, Your Honor.
Okay. So of the 9 that the state might end up using, so let me ask the state. So you expect to question Mr. Sumlin and have him essentially testify as to the substance or whatever it is that you wanted, you just expect to get it in through his testimony, and only if he doesn't testify as expected would you then turn to these, or what?
We would be asking him about what is in those calls.
Okay.
I think it might be helpful to litigate them, but then it would just be impeachment. I don't know whether there are any particular objections to the subject of these calls. So it
Okay,
can't
so
hurt to.
I guess maybe we'll find that out first. So these 9 calls that might potentially get offered, is there going to be objection to any of these? To the substance within them, or?
So, as I understand what we're saying, it's kind of like the Quindarius Zachary prior statements where the state's not going to seek to admit these, but just as impeachment, and we just want to know if the subject matters are should be off limits in our view. Is that?
So I think so. I guess if they end up being offered, is there going to be some, assuming they would be properly offered for impeachment, is there some other objection?
And Your Honor, I'll also say, just to make it clean, we should probably proceed as if we're going to offer them, because even if the witness is testifying, they are still admissible co-conspirator statements. So rather than mix those 2 together,
Okay.
we'll treat them like we're just going to offer these 9.
Okay. All right. Let's take a quick restroom break, and then we'll come back. Let's take 10 minutes, come back at 3 and tackle these.